Just like keep track of.
Hello, everyone. Thank you for joining me here today for a Chicago's Best Ideas lecture. I'm William Hubbard. Many of you already know me, but for those of you who don't, I've been here at the law school now for 15 years, primarily teaching civil procedure, and that's what I'm here to talk to you about today. The intersection of the doctrinal area that I focus on, which is civil procedure, and some of what I consider to be Chicago's best ideas, which come out of both the strong tradition of law and economics here at the law school. All right, so my focus today is on civil procedure and its relationship to civil justice. Civil procedure is how things get done in litigation and in court in the course of a civil action. But civil justice is what we're aiming for. It's what we're seeking to accomplish through the use of the law and in particular civil procedure. We want the process of dispute resolution through the civil action to be one that we consider just. Now, one of the obstacles to accomplishing this is what I call the vindication gap. This is the all too familiar gap between what we think of as the law on the books and the law in action. The formal equality that the law might create between differently situated litigants and the reality that the inequalities that exist outside the courtroom in our society might replicate themselves in the courtroom, notwithstanding the formal equality that the law creates for all who seek recourse in the civil litigation system. Now, how do we respond to the vindication gap? How do we address the concerns that we have about the ability of those who might be disadvantaged outside the courtroom in achieving a fair shake inside the courtroom? Well, there's a long-standing conventional wisdom in this respect. And the idea is, well, that's what civil procedure is for. It is to create rights that enable people to invoke the machinery of the legal system in order to achieve their ends in the civil litigation. And the rights that we create should insulate the litigation process from the world outside of the courtroom. Should somehow create a different world within the courtroom than the world, the market-oriented, unequal world outside the courtroom. Now, this view has been around for a long time. There's a very famous paper from, at this point, 40 years ago by Owen Fisk called Against Settlement. That's Judith Resnick there, who's talked a lot about what she would call the erasure of rights, the way that various intrusions of private ordering, such as private arbitration and other alternatives to the public civil litigation system, lead to the loss of these protections, the loss of this idea that civil procedure operates as a bulwark that insulates the dispute resolution process from the inequalities in our economic sphere. So these are two titans in the field of civil procedure. They're both at Yale, and their scholarship is, I think, representative or emblematic of the prevailing view. Now, what I want to offer is an alternative to this very rosy picture that we have here. I'm trying to use more AI these days, so I had AI generate a picture here that was attempting to capture this idea that through rights and procedures and more process, we can achieve sort of this ideal of equal justice. And so I kind of sum up this notion, this conventional wisdom, that more procedure means more justice. We just need to have more procedures, more rules, more rights, and that's how we assure equality in the justice system. But I want to add a question mark to the end of that. I want to question that, and to do that, I want to bring in some of the intellectual tradition that's closer to home, right here in Hyde Park, at the University of Chicago. So, as you've probably heard many times, the economic analysis of law, so-called law and economics, really had its birthplace right here in Hyde Park between the economics department, the law school, and the School of Business. These are two of my mentors when I was a graduate student in the economics department many years ago. That's Gary Becker on the left and our very own Bill Landis on the right. And they were true pioneers in the economic analysis of law. And specifically, of course, Bill Landis wrote a lot about the law and economics of litigation and trial. And one of their great innovations was recognizing the ways in which economic forces, supply and demand, incentives and prices, could operate in domains outside of formal, explicit markets. Do you guys know the story of Gary, how Gary Becker kind of came up with his groundbreaking work on the economics of crime? So he was giving a talk. He was at Columbia before he came to the University of Chicago, and he was supposed to give a talk at Columbia University, and he was looking for parking. And those of you been in New York City know it's very hard to find parking there. So he's driving around looking for parking, and he can't find a parking space. And he's thinking to himself, "I'm going to be late." And he says, "Well, I could always park illegally," he thought to himself. So he said, "Well, should I park illegally?" And he said, "Well, gosh, is it worth it to me? Is it worth it to me to park illegally? What's the cost of getting a ticket versus the cost of being late to this talk he's supposed to be giving?" And he decided it was worth it. It was worth it. He was going to park illegally. And what that made him realize was, well, wait a minute. Just like, financial markets, stocks and bonds, or goods and services, we can think about criminal behavior as responding to prices and incentives as well. Now, he was not the first person in history to think this, but it rejected the prevailing view in sociology and criminology at the time, which was very much focused on this notion, now I think largely discredited notion, that the key to understanding criminality was to identify the criminal mind. There are some people who have a criminal mind, and if we can just figure out who they are, we can lock them up and protect society from them. And Gary Becker, seeing himself deliberately committing a crime, thought to himself, well, I don't think of myself as a person with a criminal mind, but I am responding to incentives. There are costs and benefits to breaking the law. So he built out this whole framework of economic analysis of crime, and that became one of the foundations of law and economics today. And the law school has been home to many great minds, best ideas. This is Chicago's best ideas, so let's talk about some of them, who have taken this idea of bringing the economic mindset, thinking about supply and demand, thinking about incentives, into every corner of human life, including every corner of the law. And here are some innovators that have talked about the idea of markets existing in places where traditionally we didn't think about markets. So Ronald Coase, most famous for the Coase theorem, of course, which he, as an aside, he actually didn't invent. That was George Stigler. But the Coase theorem is just one of his monumental contributions. He championed the use of markets in auctioning off the electromagnetic spectrum. So all of radio, for example, television, anything broadcast over the air, how to distribute different frequencies of the electromagnetic spectrum to businesses that want to use them. His thought was, well, there should be a market for that. We shouldn't have government bureaucrats deciding whether this proposal or that proposal is better. Let companies bid on them and use it to raise money. That was his innovation of Richard Sandor, who is a generous, among other things, a generous donor to the university. His name is on the Coase Sandor Institute. He was a great innovator in the development of markets for the environment. The idea of we can trade in credits for environmental resources in order to steward our environment. And of course, the biggest name of them all, probably in many circles of the legal academy, is Richard Posner. Richard Posner, whose treatise on law and economics remains the foundational kind of document for generations of students in law and economics. He advocated for thinking about many settings in which we don't look to markets to solve solutions, but maybe we should. Maybe we should. I mean, he even so controversially argued that we should think in terms of markets for things like human organs or child adoption. So that's the tradition that I want to draw from a little bit in this talk, thinking about, are there settings where we don't think about markets that maybe we should? It's not always a good idea. I want to be very clear about it. It's not always a good idea, but it's at least an idea worth entertaining and understanding whether or not it's a good idea. Let me put it that way. All right, so in that regard, I want to build on another Chicago idea. This one's courtesy of Omri Ben-Shahar, what he calls the paradox of access to justice. And my kind of version or refinement of that is what I like to call the paradox of procedure. The basic idea is that as we try to improve and create access to justice for all, we may end up taking steps that are counterproductive, that may actually make the system less equitable, less accessible to those who are the most vulnerable in society, rather than more so. That's the thesis. That's the claim that I want to defend, that there is a paradox of procedure in this respect. And I want to pair that with a constructive idea, what I'll call the paradox of markets, is that even though what we are trying to defend the legal system against, to insulate it against, is the inequality that is in part created by market forces in our society, it may be markets themselves that can help provide that protection and that equity within our legal system. Why is this? Well, I think it's important to begin by pointing out that our existing approach, which is to say more rights and more procedure, has failed to do what I think it aspires to do, which is to insulate the litigation process from the very market forces that create the inequality that we're worried about. Market forces continue to exist and to exert their influence on civil litigation. I think, and I'll try to show you why I think this is inevitable. And by doing so, replicate and perhaps even magnify the very inequalities that we might be so concerned about affecting the litigation process. So the choice that we are faced with is not to either accept markets or reject markets in procedure. My claim is markets are going to operate whether we want them to or not. The question is whether we should ignore the fact that markets are operating, put our head in the sand, and hope that the rules and reforms that we put in place protect the values that we're trying to protect in the system, or we can try to consciously account for the ways that market forces operate in our litigation system in order to improve how it operates for everyone. Law and economics got to talk about externalities. So let me just very briefly kind of lay out what I think some of the economic forces are that operate within civil procedure before I turn to some examples of what I think are market forces operating in specific areas. So I want to get a little bit more concrete. But let me just make one conceptual point here, which is there's all sorts of externalities in the procedural context, and we want to organize them in a way that allows us to identify what solutions might be available to us. We talked about, my co-author Ronen Abraham and I have a series of papers, and we're working on a book project called Markets for Justice in this respect. We talk about the different spillover effects in procedure. So one we call system externalities, and the idea of a system externality is like congestion on a highway. The more cars on the highway, the slower everybody has to drive. Likewise, in litigation, one example of a system externality is the more cases in a courthouse, the slower all the cases go. It's this idea of an individual case has an effect not just on itself, but on sort of the entire system, the flow of cases through the entire system. A narrower form of externality is what we call strategic externalities. This is within a case. You can say, look, I'm doing something in this litigation. It's costly to me to do it, so I'm bearing some of the cost. There's a benefit to me to doing this, so I'm capturing the benefit as well. No externalities yet, but some of the cost of what I'm doing actually ends up being picked up by the other side. So I'm able to impose costs on the other side in a way that doesn't hurt me, it hurts the other side. And you can see how this type of externality is a particular concern in litigation because it's an adversarial process. Not only is the benefit, for example, of a discovery request that I gain information, that's great, but there's a second benefit, which is I like the idea that my opponent is burdened by this. Now, that shouldn't be a benefit from a societal perspective. We don't want anybody being burdened, either side. But the reality is, in an adversarial environment, if I'm burdening my opponent, I'm making settlement look more attractive to them on terms that I prefer. And so that's the nature of the strategic externality, is offloading costs on the other side for strategic advantage. That's a private gain, but it's not benefiting society in any way. It's just an arms race, so to speak, between the two sides of a litigation. And then finally, we talk about public goods externalities. Now, this is the fun stuff. This is the happy story about externalities in civil litigation. Litigation, I think it's important to remember, has lots of positive spillovers as well, especially even beyond the courtroom. Most importantly, the litigation process is the source of precedent, the precedent that explicates and changes, clarifies the law for all of society. It also does other things. It might reveal information that is hidden that really should be public. Lots of litigation has exposed wrongdoing that has only become public thanks to the process of civil discovery. Jury trials are a way for people to become involved in the processes of government. It's a form of civic involvement and so on. So there's lots of positive externalities as well, and we refer to those as public goods externalities. Okay, but let's be more concrete. I've made the claim that there are markets in procedure. They already exist. They are inevitable. So we need to design procedure in a way that is mindful of the markets that are there, what I like to call market-mindful procedure. So let me try to make the claim that there are already markets in procedure, and so we're just kind of stuck with them. So I'm going to briefly describe three examples. Business courts, what I call the market for precedent, and then the use of pricing, both implicit and explicit, in complex litigation. All right, so lightning lanes in the courthouse. Disney keeps changing what they call their fast way to pay extra and cut to the front of the line. I think it's currently called lightning lanes. So what are lightning lanes in the courthouse, not at Disney World? Well, the idea is if you pay extra, right, you get to be on the fast track to go on the ride rather than waiting in the long line with everybody else. Now, we might debate whether this is a good thing or a bad thing for courts. That's not my claim right now. My claim is whether we like it or not, that is what courts already do. Where do we see this? Well, most obviously, there's this idea of arbitration, of diverting cases away from courts into arbitration. Arbitration is more expensive. It's actually much more expensive when you look at filing fees than going to court. But in some cases, it can also be much faster. That's not my focus, actually. That's not my focus because the shift to arbitration does a lot more than just speed a case up. It changes a whole host of values that we might care about, such as publicity and transparency, the creation of precedent, and so on. All those public goods externalities I was talking about a moment ago. So I don't want to emphasize arbitration, although it's worth thinking about. What I want to emphasize is the way that courts themselves create these menus, where you can say, okay, this much, and you can go this fast. Pay this much and it's a little bit slower, pay this much and it's a little bit slower. You don't see this in federal court, I want to emphasize that, which is why this idea might be unfamiliar to you, because we spend a lot of time talking about federal court here at the law school. But in state court, they are all over this idea. A lot of states have specialized courts, often for business-to-business disputes, but other types as well, but primarily business-to-business disputes. And the prices are different. But if you pay more, you get assigned to a special roster of judges who will move your case along more more quickly. So this is an example where courts are quite explicit in saying you can pay for faster service already. Now, there's a couple of ways to think about fast lane in this context. And as we think ahead to the prescriptive rather than the descriptive, I think these analogies are worth considering. You might be familiar with TSA pre-check. You get to go through a faster line. You have to pay a little bit, and you give up a little bit of privacy. You have to fill out these forms and give certain information to the government before you can do that TSA pre-check. So there's a way of saying, well, you're giving up some of your rights in order to move faster. And courts do this as well, actually, interestingly enough. Again, federal court, it's hard to see this, but in state court, this is ubiquitous. For example, in small claims courts, you're able to get disposition faster than if you file in the normal circuit court or district court or whatever it's called, depending on the state. But you have fewer rights. You might not be able to appeal a case. You might not have a right to discovery. You might not have a right to file supplemental briefs or things like that. So there's a trade-off between speed and rights. And then the more traditional approach, which is the one I've already described, is what I call Lexus lanes. It's very common in some areas on the highway. You just pay more. You just pay more and you get to go in a faster lane. And that's the business courts that I already described. Here's another example of market forces already operating in everyday procedure. Settlement, if you think about it, is a transaction where one side pays money and both sides give up their procedural rights. You're taking money and you're giving up your right to a trial. You're giving up your right to take further discovery. You're giving up your right to an appeal. There's also a whole thick, rich market of litigation funding in which investors are willing to basically give loans or otherwise provide financing to lawyers and their clients in exchange for a stake in the outcome. The legality of this depends on what jurisdiction you're in, but it's growing. And here, it's kind of the opposite of a settlement. It's a market transaction that says, I think we can make money by paying you to refuse to settle this case, by holding out for a tougher settlement. And one of the things that makes third-party litigation funding controversial is the idea that a plaintiff who might have been willing to settle for less because they needed the money sooner, now that they have this funding, they're willing to hold out for more, and they're able to extract, perhaps deservedly so, perhaps not, but they're able to extract a larger settlement from the defendant. And so that's a sense in which somebody's getting paid to refuse to settle. So that's also a way in which we see market forces operating in civil litigation today. And there's an ideology rather than profit-driven version of this, which is in impact litigation, for example, right? You might see an organization like the NAACP Legal Defense Fund or the ACLU financing the litigation, not because they're trying to make money. That's not their goal. Their goal is they want to change the law, but what they need to do is pay somebody not to settle. Pay somebody to take the case up to the Supreme Court, for example, in order to change the law. And I'll talk a little bit more about that in a bit. And then finally, a last example is in complex litigation. This is done in an ad hoc way. There aren't rules written down that say, oh, do this if these conditions are met. It's much more about courts exercising their case management power in a discretionary way. But what we see some courts doing in complex litigation is saying, look, you've already done a lot of discovery. Both sides have already gotten a lot of discovery from each other, and it's been expensive. And you know what? That's fine, because that's our commitment in the American civil legal system, is to broad discovery. But guess what? You're still asking for more discovery? The judge might say, I'm skeptical you actually need this. But if you really think it's that valuable to your case to get more discovery, here's what you're going to have to do. You're going to have to put your money where your mouth is. You're going to have to pay the other side their cost of digging up the additional discovery you're asking for and giving it to you, rather than imposing that cost on them with nothing in return for them. So that's a way of basically placing an explicit price tag on further discovery. And that's, as I say, it doesn't happen routinely. It's more of the exceptional case that does this, but it is part of our legal practice today. Another example of this that is more implicit is the so-called lone pine order in multi-district litigation. And this is something that, are any of you familiar with lone pine orders or MDL? No, not so much. Okay, maybe one or two. Okay. So MDL is this process that consolidates zillions of related cases together that might not be suitable for class action treatment because the individualized facts of the injury, for example, might be very case specific, but they're all related. So it could be that the same defendant manufactured the same medical device or pharmaceutical product that allegedly injured all of the plaintiffs. And what you see in these cases is they create great efficiencies in terms of resolving through a mass settlement all of these thousands of claims much faster and at less cost than if each of them were litigated individually. That's great. What's the downside? Well, there's a couple of downsides, and I'll get back to the second one in a bit, but let me just talk about one of them right now, which is these settlements are basically cookie-cutter deals. There's a committee of plaintiffs' lawyers that negotiate a settlement that more or less doles out kind of fixed amounts from a fixed menu to all of the cases. And what that means is if you actually have a really weak case, but the case is able to kind of hang in there and not get kicked out of court until the settlement arrives, you have a chance to collect the same cookie-cutter amount of settlement as somebody with a much more meritorious case. And so you see these so-called tag-along cases, these cases of dubious merit that just try to sneak their way in to the MDL. And what courts have done in response to this is the so-called lone pine order, which says with your complaint, it's not enough that your complaint simply describes the relevant facts and contains a demand for relief. You actually have to attach evidence showing the court this is the basis for what I'm saying in my complaint. Now, if you're saying to yourself, well, wait a minute, I just spent like 6 classes in Civ Pro in the fall of my 1L year talking about notice pleading and plausibility pleading, and the one thing I'm absolutely certain is never, ever, ever required under the federal rules of civil procedure, it's that you attach evidence to your complaint. That is not what we do in America. If that is your recollection is correct. Nonetheless, this is a routine practice in MDL. We can talk about whether there are any sort of legitimate doctrinal foundations for that another time. My point today in this lecture is to say it's already happening. The courts are saying because there's too much supply of cases, or maybe I should say there's too much demand for the MDL, we're going to raise the price of getting into the MDL so that we can try to cut off this excessive number of cases. So that's not an explicit price. They're not raising the dollar amount of the filing fee, but they're making it much costlier for plaintiffs to join the MDL. And I think that's a great example of implicit pricing in the present day. All right, so I want to shift now from the descriptive. I hope I've convinced you that there's at least a meaningful amount of market forces that are already in play in litigation, and they're not going anywhere, so we might as well accept this reality and try to do something about it. I want to turn now to the prescriptive and say, well, what should we do about it? What can we do about it? How might we actually use market forces to make things more equitable rather than just letting the chips fall where they may, which currently may not be equitable at all? So what are some market-mindful reform possibilities? I'm going to talk about 3 today. Congestion pricing in debt collection court, regulating the market for precedent in appellate litigation, and replacing monopoly with competition in MDL, which I was just talking about. These illustrations, in case you're wondering, like, what is going on here? So Standard Oil was this huge trust. It was basically a monopoly over oil that had huge profits, incredible political influence. Obviously, today we're living in an age where there are very, very powerful corporations that wield a huge amount of influence over the economy and politics. So the world today is maybe not so much like the world 125 years ago or so. This is supposed to be Teddy Roosevelt, the great trust buster, who championed the use of antitrust law to break up these monopolies. Do you know who the head of Standard Oil was that he's fighting against, this monopolist? John Rockefeller, right? So it's who, thanks to him, right, I have a job here at the University of Chicago, this amazing university, this world-leading university that was funded and created by this awful monopolist. So it's funny how things work out, but the idea here is, if there's monopoly, like, well, gee whiz, we already know that monopoly in other areas is a bad idea. If we see monopoly in litigation, maybe we should also try to replace that with competition. And so the little math that I want to try to promote here is this idea that maybe markets for justice is actually how we get access to justice. So let's see some of these ideas real quick here. So debt collection courts. So debt collection courts, I don't know if you guys have studied debt collection court. It's a state court phenomenon. Some of these courts, it will blow your mind what is going on in these courts. There are Los Angeles Superior Court courthouses that will have 20 or 30 or 40,000 cases, just debt collection cases, not all cases of all types, just debt collection cases filed in a single year with, just a handful of judges trying to deal with all these cases. They're overwhelmed, and they face a Hobson's choice. Basically, crushing congestion or no meaningful sorting between valid or invalid claims. What does that mean? A lot of these complaints allege debts that may have actually existed at some point, but the statute of limitations has already run. Or they're debts that may be subject to legitimate defenses by the person who allegedly owes the debt. But what happens is these complaints are filed. There's no response to the complaint, maybe because service was inadequate, maybe because service was 100% proper and the defendant simply chose not to respond, which they can. In the latter case, maybe a default judgment is appropriate. In a former case, a default judgment is not appropriate. Even in the latter case, there are limits on how a default judgment can be implemented. The complaint itself has to be facially adequate in order for a default judgment to be awarded. Here's the thing. There are so many of these cases coming through that a significant percentage of the cases that are inadequate on their face nonetheless lead to default judgments. And what this means is individual consumers who might only owe a few $100s allegedly to a landlord or a credit card company now have civil judgments entered against them, which can have a long-term impact on their credit history, on other records as well. And so this is a real concern, is how to prevent this strategic use of, and you might say, wait, strategic use, what are you talking about? Well, here's the thing. It is in the debt collection company's interests to overwhelm a court with tens of thousands of complaints, because that means that those complaints will not be scrutinized because the judges can't do it. They physically do not have the bandwidth to actually scrutinize all those complaints. So how can we deal with this? Well, one possibility we suggest, my co-author and I, Vernon Abraham, suggest is congestion pricing. So this has just been implemented in New York City. It was very controversial when it was proposed, but it went through, and by all accounts, it's been very well received. Congestion is down, revenue is up, pollution is down, commuting times are improved, pedestrians are safer. And how do you get there? Well, it's simple supply and demand. If you make it more expensive to drive in an area that is beset by excessive congestion, people will drive less, congestion will go down, and benefits will ensue. Same idea in debt collection courts. You can say, well, look, if mass filers are creating this congestion externality on the courts, make them pay more to file. Okay, now if some individual, person is owed money and they're suing somebody to collect it, that's fine. That's what the justice system is designed to allow you to do. But if you're filing 10,000 cases, single plaintiff filing 10,000 cases, maybe we want you to think a little bit harder about whether all 10,000 of those cases need to be filed. And this would be a way to do it. And here's the thing. It's not just about reducing the congestion. It's also that when you charge the congestion fees, you create revenue that can then be used to actually expand the court's capacity to hear cases in a meaningful rather than meaningless way. All right, another idea, regulating the market for precedent. Now, I want to use this example because it serves a purpose in addition to just illustrating a possible reform. This is a reform that actually restricts market forces. And I want to emphasize that market-mindful regulation doesn't mean willy-nilly market promotion. Markets are going to exist, but markets are constituted in part by legal rules. And so we want to think about how to use legal rules in a way that shape markets in a pro-social rather than anti-social way. So pro-market may mean anti-regulation, but not necessarily, and I want to emphasize that. So in the interest of time, I'm going to skip settlement insurance, but I want to get back to Owen Fisk and Judith Resnick, because I want to kind of bring back an idea that they've championed and show that in some ways maybe there isn't so much distance between the traditional view and aspects of what I'm arguing for. There may be settings in which, that's supposed to say settlement, not precedent. Okay, it's this badly drafted slides, my apology. Banning or inhibiting settlement. Why would we want to do that in a world where we care about market forces? Well, we only want to do that in a setting where the private incentives are badly misaligned with the public incentive, with the public welfare, with social welfare. That's a setting in which we want to say to ourselves, well, this market needs to be regulated more, not less, because the externalities are really big. Now, most of the time, when two parties settle a case in court, that's good for everybody. They get closure, their fight is over, they don't have to spend more money, the court system is less congested, everybody wins. But there may be settings where there's an opportunity to create meaningful precedent, and that's a benefit to all of society, not just to the parties. And settlement might actually prevent what would otherwise be a meaningful opportunity for the courts to do some good for society as a whole. So that might be a situation where we really want to take seriously this old idea that maybe settlement should be discouraged or even prohibited. But our claim is in very, very specific circumstances where we really identify a large public good externality. And that would be in situations such as where an appellate court has already invested a lot of time and energy in preparing, for example, an opinion that will create precedent. We might want to say, look, it's too late now to settle your case. If you really wanted to settle the case, you should have done it earlier. But now that there's been this public investment in creating a public good, the case is not going to be rendered moot, even if you say you want to settle the case. And then finally, to get back to this monopoly, breaking up the monopoly idea, I mentioned how plaintiff steering committees negotiate on behalf of everybody to create these kind of large, very efficient, but also kind of cookie-cutter settlements in MDL. And MDL has been criticized for this reason because the so-called plaintiff steering committee, this elite committee of lawyers that have this authority over the whole MDL, they basically make up their own mind about what to do with the case. And then once the settlement is arranged, it's more or less a take it or leave it offer for the individual plaintiffs. And the benefit there is a very efficient, cost-effective process. So I don't want to de-emphasize the benefits. There are lots of benefits to this system. But it's also been criticized for basically cutting actual human beings, the injured parties, the people who have suffered, and the reason why this MDL was created in the first place, cutting them out of the very process of making any decisions, having any agency in what happens to this case. So how can we retain some of the efficiencies and benefits, but try to take away, weaken this monopoly in a way that allows plaintiffs to feel like, and hopefully actually have, more control and more choice in the matter? Well, Jonah Gelbach, not a Chicago person, but I want to give credit even outside of the confines of Hyde Park to the innovators in this space. He's at Berkeley. Jonah Gelbach has proposed what he calls litcos, litigation companies. The idea is these would be intermediaries who would compete for individual plaintiffs to say, look, hand over your claim to me. I'm going to do the best job negotiating a settlement on your behalf. And I'm so confident, in fact, that I'll get good value for your claim that I'm going to pay you upfront, cold hard cash, the full value of your claim, and I can't take the money back even if I settle it for less. And the idea there is by having competitors competing to bid for the value of each person's claim, plaintiffs have the ability, one, to exercise choice, to say, well, look, I'm getting this menu of options. This person promises more upfront. This person says, I'll maybe pay you less upfront, but you can be more involved in the negotiation process, whatever it may be, giving them more choice over how the litigation unfolds. And two, it'll have a second benefit of giving them some assurance that the number they end up getting in terms of their settlement amount isn't just what one group of people unilaterally decided was the value of their case. It was actually lots of people looked at their case, and you got to pick the one that valued it the most and gave you the most value. So that's the idea behind that potential reform. So I hope what I've done in this lecture is to talk about some of the ways that we can recognize market forces already operating in the civil litigation system, but also to open our imagination to really, in some ways, radically different approaches to procedure. Not radically different because they involve market forces. That's the reality we're stuck with no matter what we do. They're radical because they explicitly acknowledge the presence of market forces and try to actually turn the market forces to our advantage rather than our disadvantage. And so just to kind of give you a big picture of what the possibilities are in this space, we can talk about introducing pricing. I talked about cost shifting, loan pine orders, congestion pricing. We can talk about increasing competition. Just talked about the LitCo idea. There's other ideas that might even be a little wackier than that I don't have time for. Talking about having lotteries or prizes to incentivize people to increase litigation in areas where we think there actually isn't enough activity because perhaps it involves plaintiffs or defendants who simply don't have the resources to pursue litigation. But there are also situations where we might say, look, we want to be mindful of markets, but we think maybe there's too much competition. Why would there be too much? Well, again, when the externalities are simply too big that they overwhelm the benefits of competition. We talked about settlement on appeal. Expert witnesses is an interesting area where the law has actually, I think, without really thinking through it, has created two markets instead of one market. So the existing law may actually increase markets rather than decrease them already. What do I mean by that? Well, for those of you who've studied expert witnesses under Rule 26 of the Federal Rules of Civil Procedure, amendments in recent decades have created two types of experts, testifying experts and consulting experts. So where there used to be one market for experts, there are now two markets for experts. That's not, of course, how the rule change was described at the time. There are perfectly good reasons for the rule change, but it's worth thinking about the fact that we may unintentionally be increasing, proliferating markets, and if the market forces are operating in a way that we're not accounting for, that may be creating exactly the thing we're trying to insulate against, which is strategic behavior, economic inequality. And finally, I haven't given examples of this because this is, I think, the most radical idea, but it's tradable credits. You've probably all heard about cap and trade with respect to acid rain or greenhouse gases. What about cap and trade with respect to procedural rights, hearing dates, or the pages in briefs, or the number of motions or appeals you can file? Maybe these are good ideas, maybe they're not. I'll confess they're a little bit half-baked at this point, but I think that's in some ways the most exciting and intriguing possibility in this space, and one that I'm actively exploring with my co-author. In the interest of time, I think I might make this one my last slide, because I do want to give everyone a chance for Q&A. I just want to respond to one possible reaction to all of this, which is, oh my God, this is just more privatization of government. This is the last thing we need. And I want to be clear, this is not about privatization. This is about marketization. I think the two are often confused when the topic is deregulation. And I think it's very important to distinguish between the two because they have very different costs and benefits. And my claim is that marketization is something we do want to seriously consider. Privatization is something that I'm not making a claim about. What's privatization? It's basically saying, here's something the government does, and now we're just going to let a private party do it. So prisons is, of course, maybe the best known and most notorious example of privatization. But that's not really taking markets seriously. Why not? Because it's just taking a monopoly that the government has and giving that monopoly to a private party. And if monopoly is the economic problem that leads to high prices and low quality and inattention to the needs of the people, privatization doesn't solve the problem, and I just want to emphasize that. What does, or potentially could, not always, but what could solve the problem is marketization, saying if monopoly is the problem, we should allow there to be competition. The competition could be among government actors, therefore it's not privatized, or it could be among private actors, therefore it is privatized. But the privatization doesn't come with the package. It could be separate, it could be included. What matters is thinking about markets. Is this something that has competition? Are we thinking about prices and incentives or not? And that's really the key move that is undergirding all of these reform proposals. All right, I do want to give a quick shout out to my colleague, David Weisbach, who's written some really great stuff in the University of Chicago Law Review about how to design cap and trade for things other than the things that it's already been designed for. When will it work? When won't it work? He wasn't focused on procedure, just to be clear. That's not his thing, but it is my thing. And he has a framework for thinking through when it might work and not. In the interest of time, again, I'm going to skip this slide, except for the last bullet point. Doesn't this commodify procedure? Isn't this what you're doing, Professor Hubbard? The answer is yes, that is what we're doing. We just have to own that. But our argument isn't that commodification is good. Maybe it's good, maybe it's bad. Our argument is it's kind of too late. It's already been, a lot of procedures already been commodified. And so the question isn't, are we avoiding commodification? I think that ship has sailed. The question is, to the extent it is commodified, let's at least commodify it in a way that is socially beneficial rather than harmful. And so with that, I will end the talk and thank you for your time and attention, and I welcome any questions in our remaining few minutes.